Good morning, or maybe it's afternoon where you are viewing this podcast. I'm delighted to be here with former colleague and good friend Alex Valova to talk about construction management at risk, risks and opportunities associated with it. This podcast is a continuing series of podcasts from the Knowledge and Resolution Hub. If you haven't seen the other podcasts yet, we recommend you do so. And now, Alex, maybe you can tell the viewers a little bit about your career to date.
Yeah, of course, Sean. Thank you for having me. I've been a lawyer for a while now, spending time both in in-house roles and private practice. I'm currently working in private practice again at Stieber Berlach, a litigation firm in Toronto. I've had the opportunity to work on many great projects throughout my career, especially in-house where I was working closely with the project management teams, projects across Canada and the U.S., including large infrastructure projects, wind farms, and so forth. So all of that has taken me to this point, back in private practice, back doing litigation work, which is really my favorite thing to do.
Thank you, Alex. As the viewers will see, Alex has a diverse career across different sort of pre and post and also litigation. So, and a little bit about myself, for those that don't know me, I'm Sean Hollywood. I'm the current Vice Chair of the Canadian Institute of Quantity Surveyors. I'm a Fellow at the RICS in the UK as well, and also I've got a Master's in Construction Law. I have nearly 30 years construction experience that's taken me from UK through the Middle East and to Canada. My wife and I have been here since 2019, so that's the sort of things. So what I was going to do today as well, I have got a little prop for those that maybe know about it or have seen it before. But when I started out in quantity surveying, this was used all the time in the production of bills of quantities. So at the end of this podcast, I'm going to give the answer to the question of what types of bills of quantities was this used with. And hopefully we've some younger members that whenever they view this podcast will actually know what it is and not just old fogies like myself. So just to get into the topic a little bit more, Alex, when we were looking at this podcast, we looked at, reading up on making sure that we're fully aware of the whole topic of construction management at risk. So some of the things you see different contracts in construction used, like on buzzwords like NEC, New Engineering Contract, FIDIC, CCDC, P3s, and everything like that. So in terms of construction management at risk, what do you sort of know about it at this moment in time, Alex?
I would say it's a newer form of contract, and the one thing that I find in the construction world is that everybody is looking for the next best thing, and sometimes it does turn into a bit of buzzwords, like you just mentioned some of the contracts that have been popular out there, but this form of contract is, I would say, it's a bit newer, because ultimately it's a little bit more collaborative. And so I find that it's starting to get used a bit more in Canada and the US, but it is a newer form of contract, as opposed to something like design build, which has been around for a long time and is a preference for a lot of projects, including very large projects.
Yes, yeah. I think when I come to Canada originally, everybody was talking about P3s, and P3s were the flavour of the month at that time, or the year, and a lot of procurement models followed that route. I think at the time there was a meeting or a lecture about future contract models, and to start talking about target cost on different models, but at that time there wasn't much appetite for that in the market. Now, so construction management at risk has been around, as I kind of alluded to, buzzwords. It's been around in different forms before. In the UK, it was typically a lot of contractors, or main contractors, as they call them over there, GCs as we would call them here, have been operating this sort of model where they manage everything and they don't do self-perform every day. And that is a different model than maybe some of the traditional activities here in Canada. So what typically happened was that these main contractors would actually go and procure everything through the subcontractors, and then they would manage through the schedule and different things. So what I found in my career with that sort of management contracting was that some contractors were good at it, but then because it was flavour of the month, other people got involved, like that would normally do project management. So
Right.
that would be like maybe your Bechtels or your Hill International or Mace or different companies. So that brings a different dynamic to it, but sometimes it's not the greatest. So what I kind of wanted to touch upon is the need for these new contracts in Canada. So we talk about the traditional contracts and people getting used to and set up, but we also need new blood into the market. So that's where the difficulty is. So maybe some of the topics that you would have seen that helps entice new contractors into Canada. What sort of things have you seen so far?
Sorry, in terms of
Like what sort of things like to do with maybe surety of cash, surety of decisions at arbitration or litigation or anything like that. So to maybe with some contracts that are internationally, they have a set procedure, a construction contract form that you can follow the whole way through. That's sort of, it's not bespoke, it's a standardized regime. So
yeah, I mean, there's a lot of contracts here that are used across Canada, particularly the CCDC contracts. That was the whole point, to create this standardized regime. They've been around for quite a while now. There's different forms, of course, and design build being one of them. The point of those contracts has been to have I suppose you can call it a non-adversarial dispute resolution process, meaning, you're not in court. So trying to resolve matters outside of court in a more maybe efficient and private way, that's been a very popular approach, and it's sort of beyond the CCDC contracts. A lot of companies and including government entities are using these different approaches where they want to be out of court and they want to resolve things in that way. So that's been a very popular way across the country, and I would say in the U.S. as well, to deal with disputes.
yeah, no, I agree. So maybe just a little bit more on sort of where things have kind of gone, because the litigation, from what we know through different avenues, that it can take a long time to take and actually get a resolution. So, and that's probably why a lot of the owners are now looking for a perceived quicker resolution. So we kind of talked briefly in preparation for this podcast before, so we'll maybe talk about that later on, about the timelines on things. So
yeah, and I think that's a good topic that most people will find of interest, because unfortunately having disputes in construction is just part of doing business, especially on larger projects. So I think it's an important topic that people find interesting, and I think they as well, they should.
yes. So one of the little things in the last week, I was talking to somebody and he said that we all talk about dispute avoidance, and we should really talk about dispute management.
I agree.
As opposed to avoidance, because sometimes disputes are necessary to move these things along. So
Yeah, I think they're necessary, unfortunately, at times, and I think they're also inevitable because particularly when you have a very large project or even just a large project,
yeah,
the reality is it's not just an owner and a contractor. You have a lot of different parties on these projects, a lot of moving pieces, a lot of work happening at the same time. It's very difficult to get through a project like that with no dispute. I mean, it's possible and it's great, but chances are there's going to be at least a dispute or two that you have to get through,
yes.
and you have to build the project.
Oh yeah. So I think the like going back to, and just sorry for this, but going back to whenever I started in construction, I found that I wanted to be in something that was bespoke, and that's how it goes against the grain of what I talked about with contracts before. But I think we enter into construction work because it gets us, interest every day, gets us up, gets us talking about things. It is diverse, it is inclusive, it is high pressure, and not everything's the same, even though sometimes we fall into the trap that it's the same, but it's not really.
No, of course, and you could see the appeal of construction projects, especially ones that are sort of more public, where you're having infrastructure, you're having transit. They're just very important for society at large. So, when you work on projects like that, you do feel like you're a part of something a little bit bigger.
Yeah.
So it's great.
Yes, no, 100%. Like I've worked on a couple of infrastructure projects, and one, in fact, my wife and I, we went back and visited the area, and there's cows in the field now where we used to spend for like 4 years. So
Yeah.
it's quite different.
That's right.
But yeah, so a little bit now we kind of touch on construction management and risk, and sort of items that talk about it and how it works. So some of the items that we looked about was the introduction of guaranteed maximum prices,
Yes.
and how many little factors that tie into that. So every owner always wants, and uses this buzzword of, or buzz terminology of, guaranteed maximum price.
Yes, it's become quite popular, I would say.
Yeah,
Yeah.
and there's this misnomer that the guaranteed maximum price is the final price that you end up with, but that there's never any changes, and that's endemic in the industry at this moment in time. But in one aspect, it brings cost certainty. So there's different things that affect cost certainty, and maybe we can have a little look at some of them.
Yeah, of course. I mean, like you said, I would say this is one of the more popular things, the guaranteed maximum price that comes out of this type of contract, in terms of maybe if you ask a couple of people what these contracts entail, that might be the first thing they flag. And you can see that, I mean, you can understand why that would be important particularly to owners and owners of large projects. They are looking for some cost certainty, and I think it gives them some confidence to say, you're going to do this work, but the guaranteed maximum price is X. And you can see the appeal in that. I think the story doesn't end there, of course, as we know, because it's not just that the contractor gets that price, but there's all these different things in place to really try to work towards that in the end, and to not be above that by much. I think that's really what most people in practice want to see out of these contracts.
Yeah, I agree. It's the use of a guaranteed maximum price is dependent on not only the cost certainty but other factors as well. Also, design maturity. So, your design maturity affects your outturn cost of any contract.
Of course.
So, if your design is not fully mature or to a reasonable point, then you have lots of risk management to happen, and and how that happens in a contract, it can be very difficult. So.
Yeah, and I think that's another key aspect of this kind of contract. Sorry, where you have early collaboration, particularly when it comes to design, and the idea is if you can work together and come up with the actual design that's going to be carried out, then that just puts you on a smoother path to start. And what people often hope that comes out of that is that you have very little need for change, or almost no need for change, because you've already worked it out. You've spent the time right at the early on, let's say not right at the outset, but early on, to try and get your design in order, and then you go from there. So I can definitely see that appeal. That is also a part of the design build contracts, which are so popular here, including the CCDC form of design build. But I think this one takes it further.
Yeah.
That early on collaboration is.
I think it does.
There's more of it, and it's perhaps earlier on, and it's more involved, and the idea is you have a bit of time to work through that.
I've seen in different jurisdictions that they call it different things. Like in one series of contracts, they call it early contractor involvement, and then they call it optimum contractor involvement as well in another one. But basically, it was like a 16-week hotbed of like workshops to try and resolve that design, so that they got everything aligned, and then they rolled out that structure going forward into the contract. So one of the structure things that they had was that there was regular risk reduction meetings. They call them risk reduction meetings because that was associated with the term of suite of contracts. But the principle of it was that trying to bring that one team approach, one collaborative team.
Yes.
So bringing all the stakeholders from not internal and external, because sometimes what you'll find on a big project, because it's so large, you end up having so many people in different silos.
Yes,
and
absolutely.
And like silos could be a massive problem on just not only communication, but in the end product. If you're not transferring that knowledge through to maybe the next user. I'm not saying like the end user, but maybe there's an integration problem or something like that, Alex. That's where I see these sort of early contractor engagements, where they look at these design, specification, the stakeholder involvement, stakeholder engagement, getting that sort of rigor early doors, so they can actually have risk identification and then monitor it or reduce it or move it to something else if they can.
Yeah, and I think it's especially useful on projects, especially on infrastructure projects where you might have, you're working on roads or bridges or even something like a wind farm, and you might have more than one wind farm site.
Yeah.
There might be multiple sites as part of the same project. Of course, you have multiple parties trying to complete this work. And so I think this kind of contract model where the design is worked out early on, I think it can be really beneficial. But you do have to everybody has to be sort of in on the design part and actually try to work together to get to that starting point where you have a solid design and you can now go ahead and carry it out.
Yeah, no, 100%. I think that sometimes people rush to get into contract, and then it then starts to fall apart as you go through things. But with the early contractor engagement, early risk identification, you also you potentially reduce the number of change orders or variations going through the project. So that can help, but also as we highlighted, the fostering of collaboration through the different items on, there's different ways of doing that, and I'm sure you've seen different ways of fostering collaboration between teams. So
yeah, and I think there is something to be said to the change order point. there can be room for cost savings in this model, right? You're working together to sort something out. Like I worked on a project recently for a client where, it was an owner and that they had somebody carrying out certain kind of work for them. And the owner had an idea in mind. And I would say a rough idea in mind of what they wanted to see. But what they were, the expectation was they work with a contractor, and that contractor can help them make this idea happen. But they were not so married to it that it had to be that. If there was a better, more efficient, more cost-effective way to complete this project, they were completely open to it. And they were completely open to having the contractor work with the right people and to get to that point. So, I think there's a lot of room to have that happen and to save some money.
No, that's an excellent point. So I think I reverted to type there. Contractors QS, I was automatically thinking about increases.
Oh, right.
Not savings, but yeah.
Yeah.
No, I think, so to go back to that point about, possible cost savings, by having the contractor involved, he's they are the people that carry out this work more regularly than an owner. An owner might maybe build 2 or 3 projects unless he's, a regular or they're a regular owner.
Yeah.
So they don't have that proficiency typically of doing multiple projects unless you're like you're building retail parks and you're just shooting them out every area, location. So
you're right, yeah.
So that knowledge base is generally with the contractors. So that's what you kind of buy. But yeah, so on so that collaboration going through and making sure that the parties are talking, and I found in my career that people will say, "Oh, yes, we collaborate, we sign up to this process," but in actual fact, it's just lip service. So how do we, in the construction industry, do more than that? I think we talk about regular meetings and that, but sometimes we go through the motions. Is there maybe a different way that we can do this?
Well, you know what? I think that's all of these different types of contracts that are floating out there. I think maybe they're trying to solve this issue, right? How do you collaborate? And from a lawyer's point of view, it's a bit of a stick and carrot.
Yeah.
So, for example, that guaranteed maximum price could be a stick. So it's not to say that it all comes to that, but I think owners and contractors have to think about, what does the contract look like? What are the mechanisms there to get people moving in the right direction? Because I think, unfortunately, if everyone is left to their own devices, they may be pulling in a different direction. So, that's a big part of these contracts. How do you get these different parties to work together and pull in the same direction? I think the guaranteed maximum price is an important point.
Yeah.
We just talked about this collaboration early on, so that you're reducing the need for change orders. I have worked on projects where change orders or a dispute over a change order has brought the project to a complete halt. And not a halt for a few days, a halt for a while, to the point where, very senior people are calling each other and saying, "Hey, what's going on? Why have you stopped working? And when are you going to start working again?"
Wow.
It's quite serious. So
Yeah.
I think if you can use some of these terms together, to think about them together, how you can get to the next step,
Yeah.
I think that will go a long way, so that you can actually carry out the work and you're not fighting about change orders, for example, which are an important aspect of construction contracts. I mean, they're not a minor thing. You're effectively, from a legal point of view, you're amending the contract.
Yes.
That's what they are.
Yeah.
So they shouldn't be taken lightly, and what goes into them is very important, and how they're written is very important. But if you're working together from the start, because you have a guaranteed maximum price, and you've spent the time to do the design actually together, then I think you can have an efficient, you have the potential for a very efficient project.
No, you're right. Like a little point that you mentioned there, about the changes in the contract. For example, on one of the projects I worked in the past, we had numerous variations, but then we hadn't kept up with the page turn of the contract. And then it was, well, what are we producing our as-builts, our operation and maintenance manuals to, and then that information then is fed to the end user, which is then difficult. So there was a whole elongated phase of handovers,
Right.
which a contractor doesn't want to do because he just wants to get off as quick as possible.
And get paid.
Yeah.
That's
Yeah.
right.
So, like, some of the points I was going to talk about before, but, a contractor really wants to know what he gets paid and when he gets paid. So they're like, if you enter into any contract with a contractor, that's their primary goals. But
Of course.
so we talked about cost savings and efficiencies in project delivery, but some other items are increased transparency.
Yes.
That's typically one of the issues when you come to a change order, that you different people think that the change order should be costed at
Of course.
maybe X minus 1 or X plus 1 or whatever, and there's always a disagreement about that sort of thing. So one of the things I've seen in the past is that there's project bank accounts sometimes work, or escrow accounts as you would call them, where you can put the payments into the supply chain so you can actually see where the money's getting passed through.
Yes. Yes.
So that helps sometimes with transparency, but also, and I'm sure you've seen different routes of how transparency in these variations help. So
Yeah, and actually, the point about the bank accounts, this is something that I've seen a bit more recently, particularly where the owner might be a government entity. There is some interest from that owner's point of view to have these kind of project accounts where money is going in. And then, yes, you do have a bit more transparency about where that money is going and when, and why it might not be going out. Why isn't someone being paid?
yeah,
When owners have a bit more visibility there, it could go a long way. And I think it could even help avoid things like liens, which also can cause a lot of issues on projects. Now, on government projects, for the most part, you're not in a position to lien government property. But say other projects, which, there's a lot of other large projects going on around the country and around the world that are not necessarily government. The government is not involved, and liens can be placed. So, I take your point. I think it gives room for more transparency, which can help throughout the project.
yeah. I think it also helps. The reason why I kind of brought it up was the first time I come across it was in the UK around 2010 after the Olympics, but it was a new concept on me anyway. But what you see, and even if you're traveling around Toronto or Canada, you'll see the exact same contractors using the same subcontractors, and sometimes that subcontractor could be over financially exposed.
Yes,
So-
absolutely.
So and then that creates problems with their supply chain, because maybe they're trying to chase that turnover, and they're not so financially secure.
Definitely, yes.
Because if they're not getting paid the change order that's up the line, then it's affecting them down the line. So
Yeah.
sometimes things like that can affect.
And it could, to your point, it can start to affect projects that have no connection to each other,
100%.
right? They're just different a set of companies working on these different projects, but suddenly you have this domino effect. And if you're not getting paid on one, you might run into a problem on the other one.
Yeah, I know it, and that then ties into, risks on projects, associated with construction management at risk. So one of the items, because of all this change in dynamics, is a perceived, or maybe it's not perceived, an increased administration burden. So
Yes. I think a lot of construction companies, governments are finding that there is this increased administrative burden, particularly because especially on a larger project, there's just much more needed in the background to make those projects work, including, what is often very costly software. That is this kind of construction management software, and there's a few of them out there in Canada and around the world that are used, but they're not cheap, and you need to have the resources to set them up. You need to have people who are specifically dealing with aspects of the software, what goes in, what's coming out. Because if the data is poor going in, it doesn't really work. So you need the software, the compute. You need that software, but you also need people.
Yeah, I think in the past we worked on a case where we had to get information off different sites, as in SharePoint sites, and transmit them to external counsel, and that can be an absolutely tedious task if it's not set up properly. So, and people having the proper access, and I know this might sound like a sillyism, but we have these systems, and we end up having this special software and people that don't really know how to use them that well. And
that's part of some of the costs here is that, okay, you get the software and you spend a lot of money getting it, but then you need the people to run it, and they need training and they need time. So, sometimes companies, particularly if they might be a bit smaller, now they got a really big project and now they need to get this software. They need time to get it and to get used to it and get it working. So, I think that's an issue regardless of the kind of contract you have.
Yep.
Whether it's design build or P3 or whatever it is, or this form of contract that we're talking about. I think these administrative issues and burdens are becoming more prevalent, especially as the projects that are out there are getting bigger, and where you have maybe even smaller companies, or what the construction world would consider a smaller company, getting a bigger job. Well, now they need to adapt, and they need to make sure that they have the right things in place. It's one of the things particularly when I was in-house, I would give advice on this to people working on projects, how to organize their records so that when the time comes and others need to look at them, including lawyers, whether they're in-house or external, that the records make sense, and that you're not spending many hours to organize them, because there is a practical issue there. If you need to start a claim or defend a claim, or and it takes you a long time to gather up your documents, that is a real disadvantage.
Yeah.
That can cost you time and money. It could put you on the back foot. So I've given that advice many times to different people sort of across the country, how to help organize their documents, which sounds a bit, sometimes people think, oh, what a boring thing to be talking about, but it's not.
No, I totally. I've done some other webinars and even lectures in the past, and I typically come back to this one quote, which is by a guy called Max Abrahamson from 1979. He said the three most important things you'll learn in an arbitration or litigation at that time will be records, records, and records.
Yes. Yes, because this is what I ultimately say to people when we have these, perceived boring discussions, is that typically the party with the better records will be better off in the litigation.
Yes.
Because it becomes very difficult, particularly where you have something very contentious, to only rely on the testimony of people at a hearing. Because you get into all sorts of issues then, including whether they are reliable witnesses,
Yeah.
whether they're credible witnesses, and ideally, you don't want to be in that position.
100%.
So the better records and the better record keeping, I think you're just better off.
I think there's, like, from my side, saying, like, going back and trying to cost things and do the quantum side of things, I've found that people will say, yes, there's records there. And then when you look at the records and the quality of the records, you maybe get there, there's 10 men on site and no details of what they were doing or where they were working or whether the weather was raining or snowing or whatever. There's nothing there.
I agree. And you know what? I've seen this be an issue with very large companies, sort of owners, contractors, subcontractors, not just in Ontario, but other places, including in the U.S. This is a real issue. And part of it is, you know, when I've had this discussion with people in the past about record keeping, this is something that I highlight for them, and I think they tend to perk up more once we talk about this. It's so key, and really when you have lots of different people on these projects doing the record keeping, people on the site, people in offices, you have, the field staff, coordinators, project managers, sometimes there's junior project managers, and everybody's sort of, I think everybody is trying to do record keeping, but sometimes they don't understand what the purpose of the record keeping is, because maybe they haven't been through a dispute. And so what I've told people often in the past is, and that this includes talking to people who are in the field, is think about it from the point of view of somebody maybe 3-4 years down the line who has no involvement in this project, who's neutral, will be reading your records and potentially making important decisions based on those records. So think about it you're not necessarily writing them for yourself. Yeah. You're writing them because you might have a fight about it. And so what is that person who's looking at them years down the line, what are they going to do with these records?
Yeah, and it could be the turn of a word. What you put in your record might not necessarily portray what you meant at that time, and then trying to explain that to somebody else, and then questioning, well, why did you say that, and what was going on at the time,
and you know what, I've had people say to me in the past, especially on bigger projects, I've given the advice of, you almost need a dedicated person, whether they're a coordinator, whatever you want to call them, whose sole job is to focus on record keeping. And sometimes people will say to me, well, yeah, but that seems really expensive. I don't really have money in my budget to hire this, or not even hire, but even move a person from another project to then work on this project to do record keeping. But and I understand the reality. Sometimes budgets are an issue, of course. But the value in this to me is so significant that it's worth it.
Yeah, if it goes wrong, big style, doesn't it?
Yeah, and then you're spending a lot of time and money fighting over it. To your point, maybe fighting over what those records say or didn't say.
Yeah.
And so I actually think it's a highly valuable thing to focus on, even if it means you might have to rework your budget a little bit to fit in someone like this to have this important role. I think it's critical.
Yeah, we were looking at potential increases in risk, and I think this is a definite avenue that not only in the CMAR world, in other worlds as well, it's that administrative and record keeping and proper record keeping that we'll probably touch on it later on about witnesses and who they are and what sort of roles they portray, but the potential increases in risks associated with CMAR are the administration side of things. So so construction management selection, how do we get into that avenue?
I think that's also a very sort of hot topic, not just in this form of contracts, but just in general in construction.
Yeah.
Generally owners want to pick the best company suited for the job. And, sometimes, no, more than sometimes, it's very popular now to do some kind of tendering process. Not, typically that was associated with government owners. But that's not necessarily the case anymore. Even private owners engage because, a lot of larger companies have lawyers on staff and other people on staff who can help them set this up.
Yeah.
So they can do their own tendering or, RFP or whatever you want to call it.
Yes.
And so I think people have now gone that way, where the view is, I'm engaging in this competitive process, and I'm hoping to get the best person, and the best person should win.
Yes.
And so that's become popular, and I think there is something to it. I think it's really not a bad way to do it, as opposed to maybe doing it as, I know so-and-so, and
Yeah.
we should hire them.
Yeah.
But there is room for that, because knowing so-and-so, you could have done some great project at some point that worked out very well. There's nothing wrong with that. They've been sort of tested, and they
Yes.
did well. So there's nothing wrong with knowing people, but, that tendering process, there's a lot to be said in terms of using it.
Yeah. So what I've seen in the past now is that there can be a bit of a I'll use a phrase that another colleague that was on a webinar with me, and she had a nice phrase, it's the race to the bottom with the lowest
Right.
bid.
Yeah.
And Michelle, thank you for that. Michelle was the person before. But so what I've seen is the fear is that you get this, we call it in the UK on one project, abnormally low bid,
Yes.
where it's so low you go, well,
What's going on?
Yeah.
Yeah.
What have they missed? Why are they so many billion below anybody else? And
Yeah.
and then the other thought comes into your head: are you buying a problem here? Like, are they going to just be chasing every variation? And it happened on the project in the UK that when the review of the tender come in, the people went back to them and goes, now we know it's your tender, and it was for a public sector body as well, so you have to be careful.
Yeah.
Because you obviously you don't want to be given information that's maybe not correct, or confidentiality and all that sort of stuff. So what they did was they asked some strategic questions about the bid to make sure that the bidder fully understood what they were doing. So, I think in actual fact it came down to maintenance of a building for a so many week period. I'm putting it maybe in small terms here.
Yeah.
But what happened was that the contractor that bid, it was a competitive tender, a number of big contractors, they'd taken a flyer saying that they wouldn't have to maintain the building for a set amount of period. So, and that then put a different element of prelims onto the project. So what they typically then went to was, in selection of construction managers, was they would look at, well, not only your bid price, your health and safety record, and maybe your quality management. So what they did was they split it up 60% for your price,
Yes.
20% for your health and safety record, and 20% for your quality or sort of maybe softer kind of skills of things.
Yes.
Where that, you could give that recommendation for the contractor that you mentioned there, Alex, about, they've always worked for us before, they've always been really successful, they have a good team, but maybe they just don't have that full rigor of systems in place.
Yeah.
But whenever you're selecting them at a tender stage, you're saying, well, okay, there's a risk with these people, but we'll have to manage that risk by putting somebody along with them.
Yeah.
Make sure their health and safety is good, and that sort of process. So, yeah, then that ties into maybe some sort of legal and contractual issues that are associated with how these contracts can be set up and how they can be.
I think that's a complicated issue, regardless of the style or form of contract, P3 or otherwise, or CMAR. It just, or design build. things have become a lot more complex. You know, I've come across a lot of people in construction who are very senior, who are working on the business side, who have been doing this for a very long time. And, you know, sometimes they would say to me, well, you know, I talked to so-and-so and we agreed and we shook hands. There's nothing wrong with that. That, you know, obviously having a relationship with someone that you're working with that's amicable is great. But I think a lot of things used to happen in the past on just a handshake. And, you know, people shook hands and then walked away and did the things they were going to do and everything was fine. There's nothing inherently wrong with that. You know, as a lawyer, sometimes you get a bit tense when people say that to you, but it can work. The point, I think, is that the world has changed. Construction has changed not just around the world, but in Canada. And because there's so much at stake, there's so much on the line, I think it's very hard to do that. And there's still room for it, but generally, you know, it's not advised that you proceed that way. So, you know, setting up these contracts can be difficult. Everyone's thinking, of course, what is the best form of contract so I can get this project done? But especially on projects where you have multiple parties, and this includes the CMAR type of project. You know, you don't just have an owner and a contractor. You still have subcontractors and other parties. So I think you have to really think about how these documents fit together between the owner and the contractor. What happens sort of down the chain? Does it make sense? You know, it's I've said this to a lot of people that I've worked with. It's a real pet peeve of mine. That there's a lot of jargon in the construction world. And not that that's necessarily a wrong thing, but people place more weight on that jargon than they ought to. So one of my real pet peeves is when somebody says to me, oh, we've agreed to this contract and we're back to back. You know, okay, well, what does that mean? Well, we're just in it together. What? No, but back to back is in itself not a legal concept. You know, there are legal concepts that maybe apply when you're trying to tie different contracts together. You know, you're trying to reference something from another contract to make it applicable to the contract that you're working on. That is a thing. But that requires very careful drafting and very thoughtful drafting to make sure that they actually fit together and that it works. Because if it doesn't work, then you just have a real mess on your hands and you can't make sense of what parties are meant to follow or not follow. It's an absolute, sometimes overlooked issue, but if it's not done right, it almost guarantees a dispute.
Yeah, I've seen, to your point, I've seen people, or lazy drafting as I would call it, where they just issue the same contract to the subcontract and expect them, you know, to
sign it.
Yeah.
And the subcontractor goes, wait a minute, why would I sign this?
Yeah.
I'm doing a very limited scope of work for you.
Yeah.
And you're asking me to sign on as if I'm a party to the prime contract. Why would I do that?
Yeah, I'm not putting a train on these tracks. I'm only doing the railway sleepers or something like that.
Or excavation, or whatever. Any number of tasks, any number of construction tasks that go on. You know, and suddenly, you know, oh, they have to accept this thing that they're actually not a part of.
Yeah.
And so drafting is really key. You know, I've been in the position, especially in my in-house roles, where I've been involved in contract negotiation. So I'm not just dealing with disputes, but actually dealing with the negotiation of some fairly large contracts. And, you know, I've made a point of this in the past to say, hey, the drafting here doesn't make sense. And, you know, sometimes people will just go, I think you're making something out of nothing. But I don't agree. I think it's critical.
Yeah.
Because I have seen contracts or projects where the drafting that was set up was poor, and it absolutely led to a fight, including a fight about where the dispute ought to be. Should it be in court? Should it be in arbitration? Should it be in some other thing? Well, that's a very costly fight.
Yeah.
And a very contentious fight. So, it really highlights the need to have careful drafting, including about what might seem as a not very important thing, like what else are you trying to tie into this contract, or what forms part of this contract. Sometimes I've looked at contracts where, and this is just across the country because I've looked at many different contracts with many different parties. You have a contract and then you have what I call random floating pieces attached behind it. There are no way, when you read the contract, they're in no way connected to it. Yeah. Or it's not clear how they're connected or why they're there. But the people who added them, to them, they're very important. They might have some very specific scope of work or some very important exclusion or a list of exclusions that they thought now formed part of this contract, but if there was ever a dispute later on, you could say they're not part of it. And that's a very big problem. So drafting, including what forms part of my contract that I can later point to and say, you're either doing this or you're not doing this. Well, it has to be there very clearly.
Yeah, I found this, right, with a couple of things. And you end up talking about priority of documents.
Yes.
And contracts that include RFIs or technical queries.
Yes.
That contradict the actual other section in the document, and which one takes precedence over which. And it's just an absolute bun fight of who and what terms are in there. The other one I've seen is where the actual quotation from a contractor is included into the contract as a section.
Yes, I've seen that too.
Yeah.
Yes. Yeah.
And to me, that's absolutely nuts, because the contract is the rules of engagement between the parties and should be agreed by the parties.
And it's just critical, because any dispute that you have down the line, however big or small, goes back to that contract. What did you agree to? And sometimes I've actually come across this many times, both in private practice and in-house roles. And I've heard it from different people, from contractors, subs, smaller ones, bigger ones. Sometimes they'll say, well, you have a dispute and you say to them, okay, well, let me see what you agreed to. Mm. And then, it's not in their favor. Definitely not in their favor. And then they'll go, I know, but it's just not fair. Well, that may be, but you agreed to it. And, we live in a legal regime where we have freedom of contract. And we can agree to any number of things, and that could be a valid agreement that you then have to follow. So, I can understand that sentiment to a point, but legally, it doesn't quite work. And so I think more time has to be spent, especially on a bigger project. Yeah. Maybe on a smaller project, there's certain time and money constraints, and you sign the document and you go on and everything is fine. I've seen that happen. And maybe you do it anyway because the risk is so low. But on a bigger job, whether you were the owner or the contractor, time has to be spent. I think it's important for both parties. Yeah. It shouldn't be rushed, and time should be spent. And, people shouldn't be made to feel as if, oh, this is just a irrelevancy. Like, why are you raising that? No, it's important for both parties. They should want to spend the time.
So this ties into the next sort of point that we had, cost overruns.
A very popular topic in construction.
Yeah. So, although the guaranteed maximum price gives cost certainty, there's crucial things that are needed for a contingency plan or robust cost control, and that ties into what we talked about the systems and everything like that before. But you could end up in a problematic case where, as you identified just there before, a subcontractor or a contractor maybe hasn't got the proficiency or the systems in place to set these things up.
Yeah.
And there will be growing pains, but that then creates a massive problem with the prediction of cost overruns, which then ties into owners and how they manage their budget going forward. So,
Yeah, and cost overruns are a real issue in this kind of model where you do have a guaranteed maximum price. I mean, that is a big part of this type of contract, right? There is some room to change it, but it's not meant to be your traditional, I don't know what is traditional, but you know what I mean?
Yeah.
It's not meant to be that you have frequent change orders.
yes.
That is not the point.
No.
The point is that you have very few change orders. And so, from a contractor's point of view, if you sign up for one of these contracts on a project and you're not careful, you could have a real problem very quickly where you realize that guaranteed maximum price is a very significant problem and you can't do the job for that price.
Yeah.
That leads to all sorts of issues, all sorts of disputes. And rightly so, an owner might say to you, well, we have a guaranteed maximum price. And please look at all these other provisions where there's just very limited avenues for you to get more money.
Yeah.
And you're stuck.
Yes.
What are you going to do?
So
Most people don't walk away from large projects because there's also all sorts of consequences that go with that. And a lot of them are legal consequences, people want to avoid.
Yeah.
But you got to make it work. So it can be really difficult.
So that then ties into, well, if there is a massive cost overrun, what happens with the construction manager? Are they then liable for this cost, and how would that balance out? So there, to me, and sort of a novice on this, but even with a bit of background, I would say that the construction manager would be liable for this, but he would have to prove that he'd done all the steps to ensure that there wasn't an overrun.
Yeah, I mean, you could end up holding the bag, so to speak, right?
Yeah.
If you have all these cost overruns and there's no way under the terms of the contract for you to recoup them, then they are on you.
Yeah.
And the people who are involved in the project often have explaining to do on their end to their higher-ups. But yes, that could be the effect. So it could be, that could be a real risk for
Yeah.
this style of contract. Now, it does tie in a bit to some of the things we talked about earlier on. Ideally, you shouldn't be in that situation, particularly because you have a design
Yeah.
that you think works. But cost overruns happen even when you have a good design.
And you've done your risk mitigations as you go along, and you know.
Yeah. And I think people found themselves in this situation, especially during COVID, when things were going, things were very difficult around the world. There's a lot of disruption of manufacturing and shipping and all
Yeah.
sorts of things where people were hoping to get an item on time, and now they could no longer do that. Never mind get it on time. They could just not get it at all.
Yes.
And now they have to scramble and find someone else. I mean, there was a real issue. And I saw that, working closely with people who were running projects during that time, during COVID.
Yes.
I saw that firsthand. It was real. But, now we're coming out of that time. Now there's different issues, of course, going on, tariffs and other things. But still, when you sign up for contracts, especially the CMAR route, you just have to be very careful. A lot of homework, I think, has to go into to getting up to signing it to make sure you're on a good path.
Yeah. So on a smallism, on the COVID issue, I presented with some colleagues in September 2020, and I then looked at in March and April about the tariffs, and I looked at the slide deck that I did back in 2020, and I looked at it, and it was the exact same sort of thing, but 5 years on. It was up to a point, and then is there tariffs? Is that the new norm?
Yeah.
What's the effect?
Yeah.
And then the filtration right through. So it was the same sort of graph on it, and it was kind of funny in a way. So construction management disputes and how to set things up.
It's my favorite topic.
Yes.
I think it's an important topic. And I've discussed this with a lot of people in a lot of different areas. You know, everybody wants to position themselves strongly when it comes to, having a dispute. But a lot goes into it, and sometimes it can be quite messy.
So there's, from my sort of side, and maybe you touch a little bit more on it, but, there's buzzwords of alternative dispute resolution, there's litigation, and then there's different clauses on avenues and adjudication as well in Ontario. So
Of course.
I think that when you look at these things, you have to have a regime there that people understand what the avenues are, and also what happens if a contract is terminated.
Yes.
Is the clause survivable? Is it severable as well?
Yeah.
So on the sort of drafting of dispute clauses, what sort of advice would you say, Alex?
I would say that you prioritize it. So, when I've dealt with people in the past where we're working together to negotiate a contract, the people who are on the business side of things, and I completely understand it, they're focused on, they have their own sort of wish list that they want to see. And it might include, how you deal with changes, how you deal with unforeseen issues, scheduling things. That's obviously very important because you're trying to get a job done. But from a lawyer's point of view, I generally put the dispute resolution mechanism as a top item on my wish list of what I want to see. And I typically have spent a lot of time on it, particularly on a big project where you have a lot of different parties, because it has to make sense. And, obviously you've seen this. This is not just in Canada, around the world. People are moving away from going to court for various reasons. They don't want to be in court. But for one of the main reasons they don't want to be in court is because they want their dispute to be confidential and to not be out there in the public realm. And I can understand that. That's something owners want, but that's also something that contractors want. They want this to be dealt with privately, and then they move on. I get it. But, there's even work that goes into making sure that can happen. So, I've talked to people where, we're looking at a contract and it just doesn't make any sense. The person who read it on the business side thinks the contract says if there is a dispute, you go to arbitration and that's it. And you do nothing else because I want it to be private. Well, if it's poorly drafted, that's not it. And in fact, it could be that you can't force someone to go into arbitration. And the thing that you've agreed to in practice is that you go to court. And the one thing I always say to people, regardless of whether it's about dispute resolution or not, it could be other terms, is that whatever litigation method you chose, court, arbitration, whatever it is, that is a process to deal with disputes, but they're not there to save you from a poorly written contract. Mm. So you got to live with the contract you have. And so I think I mentioned this earlier that, I've had a project I worked on where a big part of the fight was, where will the dispute be? Will it be in court? Will it be in arbitration? If it's an arbitration, will it be in Ontario? And will it follow the Arbitration Act? Or will it be in a different province and follow the rules of what's ultimately a private institute that was created that has their own set of rules? Well, those are very different things. And yes. I can tell you from experience that getting to an answer was very costly. And the answer was court. Court is the place you want to be. That's just what the contract said. And when you read it all together, that was the outcome. But that's just to illustrate the issues you can have.
Yeah.
And The other thing I would add to it is that this is a very popular view in construction, not just in our province, but in other provinces, and I've seen it in the U.S. as well. People are so set on arbitration because, not just because it's private, that's a main issue, but because they also perceive it as being a lot faster and so a lot more efficient. Oh, and sorry, and I should add, and more cost effective. I've seen at this point, I've seen all of the different dispute resolution mechanisms play out, including, of course, court. And I'm not sure I agree with that sentiment, that arbitration is the absolute be-all and end-all way to resolve your disputes. Arbitration can be incredibly expensive because you're not just paying for your lawyer's time, you're paying for the arbitrator's time. And if they're a panel of 3, well, that's huge.
Yeah.
Or even if it's just one arbitrator, the cost can be really astronomical. And what I have found is that it is not always faster. In fact, I have seen times where it moves a bit slower. So this is just to say, I think people should give it some thought, especially on a bigger project. Don't just get married to the idea that you must do this one thing.
Yeah, I would agree on that. But, like, for example, on one project in the past, what they did in terms and conditions, they listed the panel members, and there was about 20 of them listed that you could go to because part of the issues I've seen is not only with an adjudication panel but in an arbitration panel, getting an arbitration panel set up, it's that the panel has to be agreed with by the parties, and you might have an objection about one person because maybe they're perceived to be contractor friendly,
Sure.
or another one's owner friendly, or
Sure.
doesn't have a background in the topic that is being arbitrated, or I'm talking if it's an individual item, but sometimes arbitrations end up being these kitchen sink things where everybody's throwing everything into the pot, and
Yeah.
it's a whole rigmarole. But yeah, that can stall the process. But like from my experience, an arbitration could take an average of 18 months.
Yeah, absolutely.
Which is on par with court as well, litigation.
It can be, depending on the kind of project that you have, depending on the kind of dispute you have. Sometimes projects go poorly and you have a number of disputes, a number of issues at hand, or you have maybe one more discrete issue.
Yeah.
So, and the other thing I find that I've come across this a fair bit. I think people, particularly if they're not just that they're not lawyers, but maybe they're not lawyers who have a litigation background, I think they perceive these other methods like arbitration or, referees are also very popular. I've dealt with a few of those cases where you effectively submit your case in writing. Okay. And there is an efficiency to that. Referees can be, I've seen them used across the country. You pick a person, they're usually a lawyer who are maybe now doing mediations and arbitrations, but they also do this kind of referee work. And then you sort of set up a timeline for your matter to be dealt with, and both parties make their pitch in writing. So the whole idea is you really put it out there. You put it all on the table, and then you might have some time to give oral submissions to that referee to really make your pitch.
Okay.
But it's meant to be it's meant to be kind of a quick process.
Okay.
And I've heard people say, "Oh yeah, I want to do I want to go in front of a referee or a arbitrator or a mediator because I don't want to be in litigation."
Okay.
Well, they are litigation.
Yes.
It's just, court alone isn't what amounts to being in litigation, right? Even in front of a referee where you're, maybe it seems a bit more innocent or easier or more efficient, you're still dealing with a neutral third party who is going to make a decision. And there's going to be a winner and a loser.
Yeah.
Or there might be two losers. Both of you might. It's possible.
Yeah, babe.
Right? But generally, there's a winner and a loser.
Yes.
And it could be the owner, it could be the contractor, it could be a sub, could be the winner.
Yeah.
So, that is litigation. And so sometimes I think because people perhaps misunderstand what litigation means, they're a little bit more casual about some of these other different options out there. But to me, from a lawyer's point of view, there's nothing casual about them.
Yeah.
They require a very similar, if not the same amount of effort. There's still procedural rules, even if they look a bit different. There's still rules of evidence. It's not a free-for-all. And typically the decision maker is a lawyer. Judges are lawyers, arbitrators are lawyers. I know there's been some interest in moving away from that, so occasionally people will use somebody who's an engineer.
Mm.
And not that there's anything wrong with that. There isn't. But a lot of the disputes that are out there in the construction world, it's not just about the technical work. There are legal issues at hand. And somebody who understands the rules of evidence and procedure
Yes.
is sort of well suited to deal with them. But whether you're in arbitration or you're in front of a referee or you're in court, you are in litigation. So you have to take it seriously. And that's where some of the other things that we talked about tie in, this record keeping, for example. That really matters.
Yes.
So, I try to guide the clients that I have, whatever process they signed up for, whether it's one of the ones we just talked about or it is court, I really try to guide them through it and for them to understand it's a serious matter and there are consequences and you could win or lose. And it might be that you sort of have to live with it. It might be that you have no further recourse or you have very limited recourse.
Okay.
So,
yeah. So we've spent a little time talking about all different aspects of CMAR and how things can go wrong and maybe go right and what processes you want to get involved. So in summary, what would you suggest that you, an owner or a contractor do, just as maybe a couple of minutes of a summary of what they should do?
I think you got to really look at the project at hand and not rely on, sort of taking a contract that you have lying around and just dusting it off and repurposing it or just reusing it, changing names and dates, because I have seen that a lot.
Yeah.
That generally doesn't end up well.
Okay.
Because every project is different.
Yes.
And every project has different issues, and some of those issues could be really significant. So, okay, maybe you can use a contract that you have as a template, whether it's design, build, P3, CMAR. But then you have to really spend a little bit of time and think about what you're doing here and what you're trying to achieve and who you're dealing with. What kind of parties are you dealing with? How many of them are there? What's going on? To make sure it's tailored. I think the contract has to be tailored to every job. And that might look different depending on the job. It might be some minor tweaks, or it might be some more significant tweaks, including on any number of things that we touched on, including on the design process. Maybe an owner, even though they're relying on a contractor for the design, maybe they need to be more involved, or maybe they need to be less involved. But that has to be addressed, and you really got to give it some thought. I think that's my sort of number one top tip.
No, that's excellent. So I would just add into, and I liked where you went with the back-to-back terminology earlier.
Yes.
I've seen it so many times where they try to, the main contractor typically tries to flow down the same contract to the subcontractors that are not doing part or a tenth of the role that they've been forced into looking at this contract for. So I think that when we look at any form of contract or any form of procurement, I think there needs to be strengths and weaknesses done on the design maturity, the availability of lands, the perceived or the need for delivery on the timing of delivery, the cost. Obviously, we're talking about guaranteed maximum prices, so the cost is key on this, but also the quality. Do we want to make sure that the end user doesn't have issues with quality in the future? So I think all these things tie in a little bit. So thank you, Alex, for sort of an enlightening discussion. It's definitely helped me more so, and I'm hoping the viewers will be the exact same on this. And I just wanted to go back to the question I asked at the start with my little prop, which I can't find at the moment, but if you see me moving around pieces of paper, that's what I was looking for. So I asked what type of bills of quantities was that prop that I typically used for in the past. And the answer is cut and shuffle bills of quantities. We don't use them anymore because we've moved on and we're now on Excel. But traditionally you would have pieces of paper which would have a hole in the top corner, and then you would lift the takeoffs from one section, say the garden in one block, and then move it to another block, and then you would collate them all together and do a summary sheet. So sorry, I'm being a bit in the past on that, but now we have Excel. So,
No, that's great.
so thank you for everybody listening to this pod, and that's it.
Thank you so much.
Thank you. Bye-bye.
Bye-bye.